Hey everyone, Harry here to talk about a truly bizarre and it seems to me pernicious order from Judge Eileen Cannon in Mar-a-Lago. It just gets worse and worse with her. Early out of the gate, her indulgence of Trump's crazy efforts to get behind the search warrant and appoint a special master, they seemed, crazy and very uninformed, unsophisticated, maybe just sort of rolled by Trump. But now, as the time goes on, the one thing that's really obvious to me that I just think there's no other hypothesis is she is trying very deliberately, and I would say craftfully and in a way that's not how judges are supposed to work, to do pro-Trump rulings in a way that keeps her insulated from an appeal that would then potentially be coupled with a motion to recuse. That's one. And then two, she's really leaning heavily. She's really putting her thumb on the scale heavily for Trump. It's very hard to dismiss the hypothesis of real bias on her part and, basically trying to figure out a way to do Masala at a minimum by delaying things and at a maximum by getting rid of the case. And that getting rid is in really vivid display in this order. All right. So first, the order, which comes out of nowhere. The context, to the extent we have it, is Trump's really bogus argument that he's tried in a series of settings about the Presidential Records Act. And the Presidential Records Act it's ironic that the way he's using it, because it was passed to keep presidents to establish that presidential records belong to the government or the people. I make the distinction only because some of them involve highly classified, dangerous information and so-called national defense information, which I will get to in a moment. And Trump has twisted that in knots and tried somehow to make of it an entitlement to telepathically convert any record that he chooses into a quote unquote personal record. Now, first, that's totally unsupported in the act, which tries to single out diaries and a few personal things, and not, for example, and you can imagine what it would be like if it were otherwise, say national defense information like how to attack Iran or what our secret reports on Putin are and the like, including the Iran piece is not hypothetical, right? It's what he actually took down. So he's trying to say magically, completely contradictory of the whole point of the Presidential Records Act, basically by the act of putting stuff and having aides put stuff in boxes, he automatically exercised magical powers under the Presidential Records Act. So it's a total bogus assessment or interpretation of Presidential Records Act. But as with so many of Trump's arguments, it doesn't matter, because even if somehow this were correct, it would in no way, zero way, not a chance in the world way, insulate him from the criminal code. The Presidential Records Act designates some things are personal, most are not. And has a civil remedy for people trying for a president to say, I want something that's personal, but in no way changes or trumps the criminal law that says if you have unauthorized possession of national defense information, that's a crime. And it's also a crime, of course, to obstruct justice and do everything he did, ignore subpoenas and the like to try to get it back. So it's, on his part, a wrong theory of the Presidential Records Act and an irrelevant theory of the Presidential Records Act, because it could not possibly be a defense to the criminal charge under 793 that he has unauthorized possession of national defense or information. All right, that sets the stage. Now, he's been making these claims generally, including in a freestanding way, but also kind of folding them in. So saying, for the purposes of the president and the president alone, 793 is unconstitutionally vague because it talks about unauthorized possession. Well, what could that mean, since the Presidential Records Act, by his twisted logic, authorizes possession and the like? Okay, so it's really both widespread and absolute garbage. Now comes Judge Eileen Cannon and issues an order from the planet, from the planet Mongo, which I've just made up, wherever that might be, but it's out of the solar system, where I've never seen anything like it, and it directs the parties to construct two different hypothetical jury instructions, each of which, well, I'll read it in a moment, but let me just say why I jumped to the pernicious part, because she is wanting to get the government to slightly, hypothetically, in some way endorse the notion of his absolute verkauft Presidential Records Act theory, but in the context of jury instructions. Why is that so worrisome? Because once we get to trial, if she makes a ruling, a lousy ruling, it doesn't matter, and dismisses the case, jeopardy has attached, and he cannot be retried. She could make a ruling about the Presidential Records Act that is a joke, but the joke would be on the country, because it would mean that he couldn't be retried. So with this kind of order, she seems to be setting the stage to somehow get the DOJ even to hypothetically discuss the notion of a jury instruction. I'll get to it more precisely in a moment, under the Presidential Records Act, which could only be useful to have such a jury instruction. And given his views of the Presidential Record Act, Trump's, if she in any way endorses it, that would mean at the jury instruction stage, or in the trial stage, she would say, okay, and even the United States discussed this previously, and I find that it applies, and I dismiss the charges against Donald Trump, and they can't be retried. It's really foreboding. Okay, and let me tell you exactly what she did. And what's before her are pretrial motions about things like the Presidential Records Act to dismiss, and not anything like this at all. But by the way, this of a piece with what she did with the vagueness challenge, which is a total bogus non-starter of a challenge. And she had to say, yes, it's not valid. But she said, this was just a few days ago, Trump, you can re-raise it during the trial, which poses the exact same threat, that she embraces a total garbage theory, dismisses the case is over, cannot be retried, she can't be recused. It's just a complete distortion and manipulation of the system. All right. So here's what this order that comes out of nowhere. You might expect an order like, are his motions to dismiss valid? Are they invalid? Instead, we get order requiring preliminary proposed jury instruction. And so they have a couple weeks, and she wants proposed jury instructions. That's something you normally give in the pretrial period, often even as the trial is heading toward a conclusion, because that's when you'll fight over jury instructions. And she says, and it is it's really hard to kind of describe how incoherent and produced by an earlier version of ChatGPT or something that just these non sequiturs are peppered through this 2-page ruling. But she says the proposal shall take care to specify in incorporated briefing as necessary, a separate briefing, exactly what factual questions are reserved for the jury in light of these recently argued motions. All right, the jury's got factual questions reserved. Well, what kind of factual questions? Well, with respect to the proposed language on unauthorized possession specifically, the parties must engage with. Really weird way to put it. Engaged with. So you have to like kind of play her game of engaging with two different scenarios, each of which is just completely lawless and with no legal anchor at all. So engage with the proposition that the earth is flat, and then engage with the proposition that E doesn't equal MC squared. I mean, when, these are so just try to assume otherwise. Engage with it, government. Engage. I mean, one can engage. I can engage with the idea that there are, dragons on the other side of the earth, or E doesn't equal MC squared. I can try to talk about it, I guess, in a high school debating society, but not in a court of law where the engagement would be to say, here's my engagement. I call bullshit. This is just completely crazy. But she could slap the United States around if they don't pretend her crazy alternate planet Mongo world is a real world. So she says, first, here's the first scenario to engage with. That where under 793, a jury is permitted to examine a record that the former president has and make a factual finding as to whether the government has proven beyond a reasonable doubt that it is personal or presidential. So she's actually saying, accept this Presidential Records Act defense. I'm not going to evaluate it as a question of law. Rather, I'll just serve up to the jury, is this a personal or presidential record? Oh, and it has to be proven beyond a reasonable doubt. So the failure to prove it beyond a reasonable doubt means that the defendant wins. And as a matter of fact by a jury, as opposed to of the meaning of the law. So she would be serving this up to a jury. It's virtually a directed verdict for Trump to say, under the Presidential Records Act, a statute that has friggin' nothing to do with this case properly understood, has the government proven beyond a reasonable doubt, as opposed to what's the right law, which would be the question for her, that this is personal or presidential. And, there would be arguments presented to a jury, but a jury is a fact finder. And it virtually compels it to, well, we don't know. It hasn't been proven beyond a reasonable doubt, et cetera. It's like a directed verdict for Donald Trump. All right. That's scenario one. That's the earth is flat scenario. Here's the E doesn't equal MC squared scenario. A president has sole authority under the PRA to categorize records as personal or presidential during his or her presidency. Again, I can engage with that proposition in part by saying it is absolutely not the law. And if it were, it would be a catastrophe that a president can just say, okay, here's our nuclear arsenal, our plans for when to use it. I'm going to call it personal, and I'm going to take it with me as I would a diary. Okay. So that's the thing you're asked to engage with. Neither a court nor a jury is permitted to make or review such a categorization decision. So in other words, not only can a president do this, but it's not subject to a court's review, because it's inherently in the presidential's power. This is like part of his whole crazy Marbury versus Madison kind of arguments that he's made to different courts. So although there's no formal means in the Presidential Records Act by which the president is to make that categorization, an outgoing president's decision to exclude what he or she considers, just considers, if Trump considers that's the end, constitutes a categorization of these records as personal under the PRA. This even more clearly than the other. If this were a jury instruction, engaging in this world at all means the jury instruction tells the jury, oh, this isn't for you. Oh, it's also not for a court. Nobody can question it. If you find that they considered it to be personal records, that's the end of the story. You can't bring the 793. Okay. So these are, at best law school hypotheticals that are clearly absolutely meritless expositions of the law. There's two aspects of this that take it from totally crazy, on all kinds of drugs, crazy and unusual, to pernicious. The first is, as I've mentioned, it sort of augurs a decision once we go to trial where she'll say these things have been hovering, or I've said we'll think about it in jury instructions. And if she pulls the trigger then, and by, mischaracterizing the DOJ's having played ball with her, jeopardy is attached and it can't be retried. That's the first. And then the second is the bizarreness of it. So this is just lathered with complete false understandings of the law, things that would be absolute reversible error were she to hold them, and really would get her bounced from the case. Just crazy. But craftily presented in terms of engaging with scenarios for jury instruction. So in other words, not really a holding of anything. So again, insulated. You think about, what is the DOJ to do about this? Aha, here's some demonstration that we've got just a nutcase of a judge who doesn't understand the law at all and needs to be off this case. But there's really, the only vehicle here, you could try to do a special writ called a mandamus when something's really sort of serious and exigent. But all she's done is all she's done. She's ordered them to kind of engage with hypotheticals that are absolutely bankrupt. But that's not exactly a holding, and I think it's very purposeful that that's the case. So again, the whole thing is legally really dangerous, wrong, etc. But two more aspects. They are, one, she's avoiding and bobbing and weaving, having a decision she could be reversed on, and it's very conscious because it's such a contorted kind of setting and exposition. And two, she's laying the groundwork potentially for an absolute, unjust and just a total lawless gift to Trump by making holdings during the trial that then would prevent from being retried. So, in case we had much doubts, the mask is off. She is truly bad news. And it's not simply that she's stumbling along and always comes to the Trump side. She's doing what she can to help him and at the same time insulate herself from being bounced from the case, which the 11th Circuit might be ready to do. We'll see what Jack Smith says in a couple weeks on this, but you can't engage, but they've been ordered to engage, and the whole thing is an academic exercise that portends a very unacademic exploitation of whatever the government says to try to dismiss the case, and yet without leaving real room right now, at least, for an order that they could bring up to the 11th Circuit, and the suggestion being that order would come after trial begins, and you couldn't bring it up to the 11th Circuit. Pernicious and Lawless. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.